under which suit can be stayed. Number 1, there is a previously instituted suit between the same parties. Number 2, the matter in issue is directly and substantially the same in both the suits. Number 3, a suit is pending between the parties or between the parties under whom any or they or any of them claim litigating under the same title. Birendra Kumar versus Basant Kumar AIR 1994 ALL 81. It is necessary for the application of Section 10 CPC that the court in which the earliest suit was instituted should be competent to decide the subsequent suit which is to be stayed. It is necessary for the application of Section 10 CPC that the court in which the earlier suit was instituted should be competent to decide the subsequent suit which is to be stayed. Object of Section 10 is to prevent courts of concurrent jurisdiction for simultaneously trying two parallel suits in respect of the same matter in issue and the same relief claimed by the parties. The policy of the law is to confine the plaintiff to one litigation, thus obviating the possibility of contradictory verdicts by two or more courts in respect of the same relief with regard to the same cause of action and to the same relief with matter. It is well settled that the working test to determine the applicability of Section 10 is whether the decision in the previously instituted suit non-suits the subsequent suit which would fall as a whole on the principle of res judicata. Number B, no, as in cross suits, the relief claimed must necessarily be different and there is no identity of relief. The court under its inherent power to stay one of the cross suit, but such a stay is not contemplated by Section 10 CPC. Section 10 CPC provides for the stay of trial of a suit in which the matter in issue is also directly and substantially in issue in a previously instituted suit between the same parties or between parties under whom they or any of them claim litigating under the same title, where such suit is pending in the same or any other court having jurisdiction to grant the relief claimed. Section 10 does not take away the power of the court to consolidate both the suits. In it may, however, be noted that a decree passed in contravention of Section 10 is not a nullity and it can be executed. Hello, welcome. Catherine Harding, welcome. What is the basis of the doctrine of res judicata? Distinguish res judicata from res subjudice. The rule of res judicata is based on the maxim namo debt lis vixari pro una et edem causa. That is, no one ought to be troubled twice for one and the same cause and interest. No one shall be troubled twice for the same cause and interest. Republica est sit farms litium etc. No one should be vexed twice over the same cause of action. Thus the rule of res judicata is based on two principles, namely public policy, that is, there should be an end of to litigation, and secondly, to avoid hardship on the individual. Daio versus State of Uttar Pradesh AIR 1961 SC 1457 versus Ghulam Abbas versus State of Uttar Pradesh AIR 1981 and Ghulam Abbas versus State of Uttar Pradesh AIR 1981 Supreme Court 2198 rule as laid down in CPC. The rule of res judicata is laid down in section 11 of the CPC is as follows. No court shall try any suit of issue in which the matter directly and substantially in issue has been directly and substantially issue in the former suit between the same parties or between the parties under whom they or any of them claim litigating under the same title in a court competent to try such subsequent suit or the suit in which such issue has been subsequently raised and has been heard and finally decided by such court. Sir William D. Gray, in his classic judgment, has laid the following principle of res judicata. From the variety of cases relative to judgment being given in evidence in civil suits, these two deductions seem to be followed as generally true. First, that judgment in a court of a concurrent jurisdiction directly upon the point is as a plea, as a bar, or as evidence conclusive between the same parties.